So you need thorough, high-stakes knowledge, and you need it fast. You're in the right place. Welcome to the deep dive.
Glad to be diving in.
Today we're tackling an area where mistakes aren't just costly, they can be, well, devastating. We're talking about the serious legal liability facing firearms instructors.
Yeah, that's a big one.
Being a trainer, it seems, means stepping into a space where the law demands total accountability, not just for range time, but maybe for years down the road.
Absolutely. It goes way beyond just teaching someone to shoot straight.
Our mission today is to really understand how this profession, so focused on physical skills, is actually wrapped up in some heavy legal risk.
Mm-hmm.
We're going to focus on two specific legal concepts that lawyers use, concepts that can, frankly, ruin careers: vicarious liability and negligent entrustment.
Right. And the sources we looked at, they really hammer this home. They basically say, if you ignore this stuff, you're just a lawsuit waiting to happen. That's a direct quote.
A lawsuit waiting to happen. Okay, let's unpack this. So, starting basic, liability. In this context, it's not just feeling bad if something goes wrong, is it? It's about this legal idea, the duty of care.
Exactly. Duty of care. It means every single thing you do, from writing your lesson plan to how you run the firing line, it's all measured against a professional standard.
And if you slip up, like forget to enforce eye protection maybe.
Well, if someone gets hurt because of that slip up, you've breached that duty. You're responsible, legally responsible, and financially responsible.
It's not just a theoretical loops.
No, not at all. The fallout we saw described is immediate and brutal. It's not just an insurance thing.
What does that look like practically?
Okay, so you're hit with a serious lawsuit. Suddenly you're facing like 3 levels of disaster. First, potentially crippling civil lawsuits. We're talking huge sums of money.
Okay.
Second, depending on how bad the negligence was, you could even face criminal charges. And third, maybe the fastest hit, is your reputation. Within the industry, it's just gone. Your credibility vanishes. Career over.
Okay, so general liability, that covers things happening right there, under your supervision, on the range.
Right, your direct watch.
But then there's this idea of harm happening, like miles away, maybe years later. That's vicarious liability, you said. How does an instructor's duty stretch that far?
Yeah, that's the kicker, isn't it? That's vicarious liability. It means you can be held responsible for what your students do outside the classroom long after they've left.
How, if you weren't even there?
Because the argument is that their actions stem directly from the instruction you gave. Lawyers use this concept, proximate cause. They connect the dots.
So if the training itself was somehow flawed or reckless.
Exactly. Or if you signed off on someone, certified them when they clearly hadn't mastered the skills, the law says you share the blame in that situation.
Here's where it gets really interesting. Because we're saying the student misuses the training and the instructor pays the price, or at least shares it. There was a chilling example in the material.
But picture this, right? An instructor teaches, let's say, an advanced defensive shooting class. Maybe the focus gets really aggressive, lots of stand-your-ground talk.
Okay.
Months pass. That student gets into some minor dispute, maybe a parking lot argument. They pull their gun, they fire, maybe hit someone uninvolved.
And when the police ask why?
The student says, I did what my instructor taught me. He said, stand your ground.
Boom. The instructor's name comes up.
Instantly. The victim's lawyers, they subpoena everything, your entire curriculum, PowerPoint slides, your notes on that specific student, their test scores, the certificate.
The actual teaching becomes evidence.
Precisely. Evidence against the trainer. The argument becomes, your words, your training, created a foreseeable risk. You put this person, trained this way, out into the world.
But wait, what if the student clearly broke the rules, went totally off script, acted recklessly on their own? Doesn't that shield the instructor?
It doesn't shield them from getting sued, unfortunately.
Correct.
Now, the student, they pulled the trigger. They bear primary responsibility, absolutely.
Okay.
But the plaintiff's lawyers, they'll argue the instructor facilitated it, that the poor training or the reckless rhetoric was a contributing factor. It helped put a dangerous situation in motion.
So even if the instructor eventually wins the case?
The cost is enormous. The source material was really clear on this. Years of legal battles, depositions, discovery. It can bankrupt the instructor or their business long before any verdict. Vicarious liability means a student's terrible decision could absolutely ruin you financially.
Okay, so vicarious liability is tied to the quality and content of the training. What about just the piece of paper, the certificate? We saw a case where the signature itself was called the smoking gun. How does negligent entrustment make paperwork so lethal?
Yeah, negligent entrustment is possibly even more direct and maybe more dangerous for the instructor. It's defined as allowing or endorsing someone to handle a firearm when they are, frankly, unfit.
And the key is the endorsement,
Yeah.
the signature.
That's often the core of it. Signing that certificate of proficiency when you know, or you should have known, that student wasn't truly competent. You're falsely signaling they're safe.
It's not just a course completion thing.
No, it's an official declaration. Other employers, licensing bodies, police, they rely on that signature being meaningful.
That reliance sets up the danger. Let's use that certification example you mentioned, the Class G license.
Right. High-risk job, armed security. Imagine an instructor has a student who, well, barely scrapes by on the qualification. Maybe they panicked under pressure, had some serious safety fumbles.
But technically passed the score.
Yeah, maybe by 1 point. And the instructor thinks, it's close enough. Failing them is a hassle, more paperwork, so they sign the certificate.
Just takes a signature. But lets this shaky person carry a gun professionally.
Exactly. And then months later, that same guard, the one who barely passed, the one the instructor maybe had doubts about, they're in a high-stress situation on the job, and they shoot an unarmed person.
Oh, boy.
When the investigation happens, guess what's Exhibit A? That certificate, signed by the instructor.
And the legal conclusion.
The court says the instructor breached their duty of care. They negligently entrusted a deadly weapon to someone they knew or absolutely should have known wasn't safe or competent under pressure.
The consequences sound final, like career-ending.
It often is. It's described as a professional death sentence. You're looking at multi-million-dollar civil suits, for starters.
Free on the money.
If the negligence is seen as really reckless, potential criminal charges, you'll definitely lose your instructor, certifications, any school licenses you hold. And forget about insurance. They'll drop you instantly. Your name is mud. It's over. That signature has to be treated like it's loaded.
So, pulling this all together, the instructor isn't just teaching shooting skills. They're acting as a gatekeeper for public safety. Is that fair to say?
That's exactly the role the law assigns them, whether they realize it or not. They're accountable for their own failures on the range, sure. That's basic liability.
Then vicarious liability for the student's actions, potentially years later if the training was bad.
Right. And negligent entrustment. If the paperwork, the certification, falsely represents competence, that signature becomes Exhibit A.
It's a heavy burden. The materials basically said, train sloppy, sign sloppy, and you will end up explaining yourself to a jury.
That's the brutal truth of it. The system sees the instructor as that critical checkpoint.
It really puts instructors in a tough spot, accountable for their actions, their paper, and their students' future actions. This definitely isn't some casual side gig.
Definitely not. Now, to be clear, students are still responsible for their choices. The saying holds, you pull the trigger, you own the round.
Okay, good clarification. A student can't just blame everything on the instructor if they act recklessly.
No, they can't hide behind the training for intentional wrongdoing. But, and this is the crucial but for the instructor.
Here it comes.
Even if the student is, say, 90% responsible for what happened, if your training was deficient or if you negligently signed them off, you're still getting dragged into court right alongside them.
Because you arguably helped create the situation.
You created the opportunity, legally speaking.
Mm-hmm.
And that's why students need to care about this too. You need to vet your instructors. Are they teaching serious safety, legal use of force, actual discipline?
Or just the flashy stuff.
Right, or just fast draws and Instagram tricks, as one source put it. Choosing a truly professional, disciplined instructor isn't just about getting good training. It's crucial self-protection for the student too. Avoids getting tangled up with someone who could land you both in legal hot water.
So what does this all mean?
It means this profession operates on a legal battlefield, essentially. If you, as a trainer, can't stand up in court tomorrow and defend every single step of your training, your testing, your certification process, why you did it, how you did it, then you really shouldn't be teaching.
Complacency is just...
It's the single most expensive mistake you can make in this line of work. Complacency about curriculum, about student performance, about signing that piece of paper.
And that brings us to the final, really provocative thought from our sources. Something for you to chew on. In the eyes of the law, your lesson plan, your signature, and your certificate are just as lethal as a loaded pistol.
That legal weight, that's the price of being a professional gatekeeper in this field.
Think about that responsibility.
We hope you continue to explore the implications of professional accountability, whatever your field might be. Consider the weight of the endorsements you give.
Until next time, stay curious, and stay informed.